Good morning. We are going to discuss today the topic discharge of tort. Discharge means extinguishment of tort or the tortious liability comes to an end. The defendant will not be liable here because of certain things which the parties have done. Parties, I am telling, the plaintiff or the defendant, either of them, they are doing it, or there are certain statutory means because of which his liability comes to an end. The discharge of tort can take place because of different modes. There are different modes of discharge. The first is death of either parties. Today what we see, when the plaintiff dies or the defendant dies, when the case is going on in the court, we bring the legal representatives and they continue the case. Right to sue and sued continues. But previously the concept was there, it is based upon one maxim, actio personalis moritur cum persona. That is, action of a person will die with the death of the person. Previously what used to happen, or this principle was based upon vengeance, that is revenge. So revenge of a person will come to an end with the death of the party. If the plaintiff dies, his revenge comes to an end. If the defendant dies, his revenge also comes to an end. His vengeance comes to an end. Therefore, the plaintiff, whom he will fight with, because the defendant is dead. And if the defendant is dead, plaintiff will not have a right to continue the case. Neither, if the plaintiff dies, his revenge comes to an end. So defendant is free now. That was the concept, actio personalis moritur cum persona. But afterwards what happened? The vengeance or the revenge was replaced by the right to compensation. And because of this compensation, the exceptions were created to the maxim. Like right to sue will continue. Means though the plaintiff dies, his legal representatives will come on record and they will continue the case against the defendant. Similarly, if the defendant dies, though he dies, his property is there from which the plaintiff can recover his compensation. Therefore, he will take the legal representatives of the defendant on record and the case will continue. So, exceptions were created for the maxim. Therefore, here though we are discussing like this is a discharge of tort, now we are having lots of exceptions because of which this discharge or this mode is not available now. In a breach of a contract, we'll take an example. The defendant has taken money. Why he has taken money? For certain things for his family members, or he has taken loan and all. He has property of his own and the case has been filed by the plaintiff for recovering money and the defendant dies. Though the defendant dies, his liability will continue because his property is there. As his property is there, the plaintiff can recover the compensation from his property. Therefore, the defendant's legal representative will be taken on record and the plaintiff will continue the case against them. Therefore, this mode of discharge is not having that importance nowadays. Okay. Death of either party. Now we have created lots of exceptions through law also. Like Indian Succession Act is there, Fatal Accident Claims Act is there, Legal Representative Act is there. These laws tell that the right to sue continues. To be sued continues. Therefore, this mode is not available now. But the further modes are there. The second mode is waiver. What is a waiver? When a person is having two remedies, maybe one is in tort and other is under some other law. The plaintiff here has to decide which remedy he will take. If he takes the remedy of other law, the tortious liability of the defendant will come to an end. He cannot blow hot and cold at one breath. This is a phrase which is being used. Means you can't have two remedies at a time. You can take one remedy. If your remedy is in tort, either you select it in tort, or if your remedy is in some other law, like in contract and all, then if you go for that, then the tortious liability will come to an end. Waiver is election between two different remedies. Injured party has a choice to waive his remedy. Therefore, waiver today is also there. The plaintiff, if he waives the remedy in tort, then he has to go for other. Or if he goes for some other remedy, then the tortious liability of the defendant will come to an end. This is the second mode where the tortious liability comes to an end. The third is accord and satisfaction. Accord means agreement. Satisfaction means you are going to get certain kind of like compensation or certain kind of consideration. So if there is a compromise between the plaintiff and the defendant, here the act of parties are there, because of which the tortious liability comes to an end. They both make a compromise. Because of the compromise, maybe the plaintiff accepts some small amount. Example, the plaintiff has filed a case against the defendant for 10 lakhs. But what the defendant meets the plaintiff and tells him, okay, I'll not pay you 10 lakh, but immediately I'll pay you 8 lakhs. We'll do the compromise. Now the plaintiff agrees for that because the long process in the court, the expenses which he has to make in the court, it is better now to get 8 lakhs. That is a good choice for him. Therefore, what he'll do, he will make a compromise agreement with the defendant. Once he makes a compromise agreement, he will withdraw the case. So the tortious liability for 10 lakhs will come to an end for 8 lakhs. So because of compromise, the tortious liability comes to an end, or you can say it has been reduced. The fourth is release. Release means what? Surrender. It is the choice of the plaintiff to file a case or not. If he decides not to file a case, means what he is doing? He is releasing the defendant from the whole tortious liability. So release means complete surrender. There is no consideration. This is the difference between release and accord. In accord, it is a compromise. Therefore, there is some kind of consideration. The plaintiff gets at least some amount. But in release, he is surrendering his right to file a case. So the defendant is being relieved from the whole liability. Consideration is not essential in release. The other mode is acquiescence. Acquiescence means exhaust. A person who knows that he is entitled to file a case neglects to file a case. He doesn't file. So his right is exhausted because he has done lot of delay. You can call this as laches. Law helps the vigilant, the active, the person who sleeps and slumbers over his right. That person is not helped by law. So if his right get exhausted, he has done laches, he is reckless, he is careless by his own rights, then the tortious liability of the defendant is relieved, comes to an end. The defendant, what will happen? He will say, okay, I did a wrong, but he didn't file a case. So his liability will come to an end. That is acquiescence. The other is limitation. See, limitation and acquiescence, they are connected to each other. Under the Limitation Act, we are having certain time which has been given by that act to file the case. Like 1 year from the cause of action, you have to file a case within 1 year, or 3 years, 12 years time is also being given. So within that time, you have to file a case. If you don't file a case, then your matter becomes time barred. Under Limitation Act, your right is not taken away, but the remedy is taken away. The court will not give you the remedy because you are late. You are outside the limitation period. Your matter becomes time barred. Limitation and acquiescence is different. In limitation, you are having fixed period given by law to you, while in acquiescence, it is just a concept. Like there is no time fixed, but you have made lots of delay. So your right is like, it is like right is getting exhausted, because the other person, that is the defendant, will consider that you are not going to file a case now. It's far, you have taken far time. You have taken such a time as if you are not having any right. Okay, now the last mode of discharge is judgment recovered, or you can call it as res judicata. Section 11 of CPC explains to us res judicata. Res judicata means same parties, same cause of action, same relief, same capacity under which you have filed a case. You filed one case, that case is being heard and finally decided. Now the judgment is final. If you are aggrieved by that judgment, you better go in appeal. But you can't file a case in a same competent court. If you file also, the defendant will say, see, the case is being decided already. Once it is decided, it is decided. Therefore, the plaintiff has recovered the judgment. Therefore, I will not be liable then. If he is aggrieved, he may go in appeal. I will be respondent there. I will try the appeal. I will oppose the appeal. But he is not allowed to file a case in a same competent court. This concept was there in ancient times also, and it was called as Purva Nyaya. Means the case is being decided previously. Once it is decided, it is decided. No person can be vexed twice. Plaintiff is filing a case against the defendant. The case has been heard on merits. It has been finally decided. Now, end. Here the judgment has been final. Better you go in appeal. If he files a case again in the same competent court on the same matter, same parties, then res judicata, as a defense, the defendant is going to tell to the judge, see, the matter is being heard, and the judge is going to dismiss the case. The judge will not hear the case. Therefore, res judicata is also one of the mode for discharge of tort. See, different modes are there. Only one mode is not remaining now. It is having its own limitation. It is having its own exception. That is the death of either party. How many modes we have seen? Death of either party, then waiver, then release, acquiescence, judgment, limitation period, and waiver. I'll repeat again. Death of party, waiver, release, acquiescence, judgment, and limitation, and accord and satisfaction. That is compromise. Okay. Bye bye. See you in the next video.